It was going to be the Federation Square of Tasmania. All these bells and whistles and everything, how great it was going to be.
Hobart's Parliament Square redevelopment takes up almost a full block of the city. A mix of restored heritage buildings and contemporary architecture, the development surrounds Tasmania's state parliament.
It's got hotels, bars and restaurants and government offices. It's a development supposed to be premium development of Tasmania or Hobart, and it doesn't provide proper access for people with a disability, parents with prams and elderly people.
For 5 years, disability advocate David Cawthorn has been fighting an uphill battle against the developers of the Parliament Square project. There are 3 entrances to the public square. The northeastern corner only has stair access. The 2 entrances with ramps are at the other end, meaning a 35-metre uphill push for David Cawthorn.
Very difficult. You've got to take breaks, and if someone walks in front of you or something, you just got to stop, and then you've got to try and get your momentum back again, which makes it very hard.
The developers are Sitter Property Group. They say they've complied with the National Disability Access Code, Commonwealth standards that require 50% of entrances, including the principal pedestrian entrance, to be accessible.
And we have had it validated on a number of occasions over the last few years that the provisions that we have made at the 2 primary entry points into the plaza, into the public buildings, do satisfy the Disability Access Code.
David Cawthorn believes the development is breaching the State Anti-Discrimination Act.
I couldn't believe that this was happening in 2021 or 2022.
John Mayo was involved in the campaign for equal access to the Brisbane Convention Centre in 1994. In that benchmark case, Queensland's Anti-Discrimination Tribunal ordered that the front entrance be modified to include a lift.
I think there's a lot of similarity between this upcoming case in Hobart to that particular instance. Why should certain cohorts be confined to using only 2 entrances when there are 3?
David Cawthorn took his complaint to Tasmania's Anti-Discrimination Tribunal in 2016, seeking one thing.
I'd like a lift to be put in.
The State Tribunal found it couldn't hear the matter because it involved federal issues. The Supreme Court disagreed and sent it back, but the developers have appealed that decision to the High Court.
I think this has got to a point where it's more of a constitutional argument about the role of a state-based tribunal versus the national legislation.
The developers have asked the High Court to look at 2 issues. Firstly, whether the State Anti-Discrimination Tribunal has the power to hear Mr Cawthorn's original complaint now that a constitutional issue has been raised. And secondly, the constitutional issue itself, whether the State Anti-Discrimination Act is inconsistent with federal disability discrimination laws and standards, and therefore invalid. David Cawthorn has a pro bono legal team for the High Court hearing.
So we've been keeping the Australian Human Rights Commission in the loop with the submission. It will set an important precedent for the powers of tribunals to hear these sorts of cases. It will also be significant because finally we will get a decision on whether or not states can impose higher standards, higher and better access to premises standards than those provided for in federal legislation.
It was joked in the beginning, but now it actually has turned into a David and Goliath battle.
Now, if Mr Cawthorn thinks that's okay, that more should have been done, then I think it's about arguing that changes should be made to the code, not necessarily, that we should be required by an individual to go off and do more than we are required to do under the law.
The Commonwealth and every state have intervened in the case, concerned about how the High Court might apply a 2018 decision that state tribunals can't exercise federal judicial power. Constitutional law expert Gabrielle Appleby says the outcome will be nationally significant.
The tribunals have the authority to determine constitutional arguments, or in fact, the minute a constitutional defence is raised, does that take away their jurisdiction? The consequences for other future litigants are going to be serious as well, depending on what the court decides, but also then on how the Tasmanian government responds.
5 years after his original complaint, the outcome of the High Court case could mean David Cawthorn is headed back to the tribunal, or it could mean more time and personal costs as he seeks other avenues with the Supreme Court or Federal Human Rights Commission.
It's just not about one individual in this case, it's about hundreds of individuals, if you can say that, maybe thousands, because this development's here for many, many decades and you want it to be able to be used to its full potential.
Hi, I'm Lee Sales. Thanks for watching this story. If you'd like to watch more of 730's stories, they are on the left of your screen. And tap on the button below to subscribe and get the latest from ABC News.